All right, so check this out. The other day, I swing by my local gun shop, literally just needed a box of 308, nothing special. And I see something that just stops me in my tracks. The suppressor wall. Normally, it's packed, but this time, it was picked clean. I'm talking barren. Like a swarm of locusts came through for NFA items. And I found out why pretty quick. Word travels fast in our world. The Department of Justice, the DOJ, finally went on record in a federal court case and admitted what we've been saying for decades. Suppressors are protected arms. The second that news hit the internet, people flooded gun stores. It was like Black Friday, but instead of TVs, everyone was racing to get their tax stamps in. So today we're digging into what really happened after that bombshell dropped. We're going to look at why shooters, hunters, and folks who've never even thought about a suppressor before are clearing shelves from one coast to the other. Let's get into it.
Look, for our entire lives, we've been conditioned to think suppressors are some kind of shady black market accessory, right? You know the deal. They sit in NFA jail. You have to fork over $200 for a tax stamp just for the privilege of owning one. And the whole process makes you feel like you're on a watch list for trying to buy an RPG. That's been the game since the National Firearms Act was passed way back in 1934. But then, the ground shifted. The very same DOJ that has been enforcing this for nearly a century filed a document in a case called Vanderstock versus Garland. And right there, in black and white, they said it plain as day. Suppressors qualify as arms under the Second Amendment. This isn't some rumor from a Reddit thread, folks. This is a formal, legal admission in federal court. Now, this didn't just happen in a vacuum. The pressure has been building ever since the Supreme Court's Bruen decision in 2022. That case changed everything. It told the government it couldn't use flimsy public safety arguments or cherry-picked stats anymore. To restrict a firearm, they now have to prove there's a deep historical tradition of that exact kind of regulation. And when it comes to suppressors, that history just isn't there. The 1934 law wasn't about stopping mobsters. It was literally passed because they were worried about people poaching deer during the Great Depression. So when the DOJ's own lawyers had to stare down the barrel of that logic, they blinked. They had to fold. I've never seen the government reverse course so quietly, but man, the impact is massive. If suppressors are officially arms, they get the same constitutional protection as your deer rifle or your carry gun. That one little word changes the entire legal landscape from this point forward. So I went back to that same shop 2 days later. The suppressor shelf looked like it had been professionally looted. I'm not even kidding. Where you'd normally see a solid row of Surefire cans, a few Banish models, maybe some dusty Yankee Hill suppressors, it was all just empty pegs. Even the consignment case was wiped out. My buddy behind the counter said they'd processed more online suppressor orders in 48 hours than they did in the entire month before. And this wasn't just happening at my local spot. I started calling around. Guys I know in Texas, dealers in Florida, shops in Arizona, all telling me the same story. Lines out the door, phones ringing off the hook, websites crashing. But here's the key, and you need to understand this part. This was not a panic buy. This was a clarity buy. For the first time ever, the government said the quiet part out loud. Suppressors are constitutionally protected. That single admission flipped a switch for thousands of people who were on the fence. We're talking about hunters who were tired of their ears ringing after a morning in the stand, new gun owners who wanted a more pleasant experience at the range, even dads thinking about protecting their kids' hearing the first time they go shooting. Suddenly, a suppressor wasn't some exotic, risky piece of gear. People saw it for what it truly is. A functional part of the firearm. Retailers told me they saw demand spike by 300% to 400%. That is not an exaggeration. Some shops sold their entire inventory in a day. It was an informed, motivated, and justified rush for the door. I remember being a kid and thinking suppressors were completely illegal unless you were a secret agent. You know the vibe, James Bond, movie assassins, all that nonsense. That entire mindset was manufactured. It came from decades of bad laws and even worse Hollywood scripts. The real story is almost laughable. Suppressors got swept into the 1934 National Firearms Act, not because of a crime wave, but because some bureaucrats were worried that hungry families in the Great Depression would use them to poach deer to put food on the table. Seriously. The law was built on a fear of overhunting, not a threat to public safety. Now let's fast forward to today. That complete lack of historical basis is exactly why the government's argument fell apart. The Bruin test demands historical proof. But when you look back at early American history, there's nothing. No bans, no regulations, nothing. They weren't even invented until the early 1900s, and even then, nobody saw them as some great menace. So when the DOJ was forced to defend these old laws under the new Bruin rules, they couldn't. They had no history to stand on. Their own lawyers had to concede that suppressors are, in fact, arms. Legally, they had nowhere else to go. Now, things get even more interesting. In the very same week, the Supreme Court made another decision, and it draws a really important line in the sand for us. They upheld the ATF's power to regulate 80% lowers and frames, basically saying they can be treated as firearms from the get-go. That was a hit to the home-build community, for sure. But it also gave us incredible clarity. The courts are officially looking at suppressors and unfinished frames in two completely different ways. Think about it. On one hand, you have suppressors. Thanks to the DOJ's admission, they're now on solid ground as Second Amendment protected arms, just like a rifle. On the other hand, you have 80% receivers. Because they still need to be machined to work, they fall under direct ATF control without that same level of constitutional protection. This distinction is huge. The courts are now recognizing the difference between a tool that modifies a working firearm, a suppressor, and an incomplete part that isn't a firearm yet. For us, it means the suppressor you want to put on your rifle just became a whole lot harder for any state to ban. That legal wall is now clearer than ever. The new face of suppressor ownership. Not too long ago, the only people really shopping for suppressors were the hardcore tactical guys or the long-range precision shooters. That is not the world we live in anymore. Dealers are telling me they're seeing more first-time gun owners asking about suppressors than ever before. You see families coming in wanting to protect everyone's hearing. You see parents buying a can to go with a .22 rifle for their son or daughter's first hunt. A huge part of this is just people finally understanding the truth. Suppressors are not silencers. They don't make a gunshot silent. What they do is bring the noise down from instant and permanent hearing damage to a more manageable level. They make shooting safer and more comfortable, especially for new shooters. With the government itself now calling them protected arms, people who were hesitant are finally seeing them as smart, practical tools. It's no longer a luxury, it's becoming a standard piece of safety equipment. And when everyone starts using them, the stigma disappears. That's how you get real, lasting change. Right after the DOJ filed that brief, you could almost hear the starting gunfire for lawsuits in anti-gun states. The big one to watch right now is a case out of New Jersey called Pudva v. Platkin. It argues that the state's total ban on suppressors is unconstitutional, especially now that the feds admit they're arms. Under Bruin, New Jersey has to prove a long-standing American tradition of banning suppressors. Good luck with that. It doesn't exist. Other states with bans, California, Illinois, New York, are watching this case like a hawk. The legal ground they've been standing on for years just turned into quicksand. The DOJ's admission is now Exhibit A in every one of these fights. The argument is simple. If the Second Amendment protects arms, and suppressors are arms, then you can't ban them. If these lawsuits succeed, they won't just change a few state laws. They could set a national precedent and bring down suppressor bans everywhere. Okay, so let's bring it back to reality for a second. Even with this monster legal victory, you still have to jump through every single ridiculous NFA hoop. The $200 tax stamp, the ATF Form 4, the ridiculously long wait times, the fingerprint cards and passport photos, notifying your local chief of police. All of that is still in place. People are still waiting 9, 10, sometimes over 12 months to get their property back. That part has not changed one bit. What we have here is legal momentum, not legislative reform. The courts are finally catching up, but Congress is still miles behind. Until they pass something like the Hearing Protection Act, or a court finally strikes down the entire NFA scheme as unconstitutional, we are all still stuck waiting in that line. So yes, this DOJ shift is a huge victory. Let's celebrate it. But we're not at the finish line. We're in this bizarre middle ground where suppressors are constitutionally protected, but still regulated like a machine gun. It's a massive step in the right direction, but we've still got a long way to go. So keep the pressure on.